You're the defendant in a domestic battery or domestic violence type of case, and the complaining witness against you does not want to pursue charges. They want to drop the case. Will the prosecutor go along? Hi, I'm Steve Fagan from the law firm of Fagan, Fagan & Davis, a criminal defense law firm here in the Chicago area. Join me for a moment while we talk about whether a prosecutor will drop a case just because the complaining witness does not want to pursue the case. Part of the problem is that people don't realize the complaining witness, the alleged victim in the case, is not bringing charges against you. The complaining witness might sign a complaint, but once they do so, or once it's done on their behalf by, for instance, an arresting officer, now the prosecutor has the right to proceed with that case. This is something called prosecutorial discretion. And at each stage of the case, someone has this discretion. Early on, it's the police officer who has the discretion whether or not to proceed with charges against you. Once the decision has been made to charge you with a criminal offense such as a domestic battery or domestic violence case, now the prosecutor has the case. In Illinois, that's the state's attorney typically. And the complaining witness now is merely that, a witness. They don't have any more control of the case, not really. Now, the complaining witness does have a say because most of the time, the prosecutor will listen to what the complaining witness wants to say. It's important to them because that's the person they are primarily trying to protect. And so sometimes a prosecutor might honor a request by the complaining witness or alleged victim in a case to dismiss the charges, but sometimes they may not. Why is that? Once again, we're back to the idea of prosecutorial discretion. That's a two-edged sword. It means that the prosecutor has the right to dismiss the charge, but it might not be the right thing to do in all cases. There might be situations in which the prosecutor decides to proceed with charges against even the complaining witness's wishes, whether the complaining witness may have been intimidated or manipulated. That might be a reason that the complaining witness doesn't want to proceed. Now, the complaining witness doesn't even have to be scared physically or emotionally of the defendant in a case. They could simply be scared of the consequences to their own lives, as is very often the case. In some cases, there is a history, and therefore the prosecutor might believe that the defendant is dangerous to the complaining witness or even to others, and therefore might want to proceed. The prosecutor, let's not forget, doesn't just have a duty to protect this particular complaining witness, but also the people of the state of Illinois. As a matter of fact, if you look at the criminal charges lodged against you in a domestic battery case, it won't say the name of the complaining witness versus you. It'll say the people of the state of Illinois versus you, the defendant. So the prosecutor has a duty to protect not just this particular alleged victim, but also potential victims in the future and the people of the state of Illinois. And they may believe that it's not in the interests of their client, which is the people of the state of Illinois, to dismiss a case simply because the complaining witness now has cold feet. Now, there are other reasons a prosecutor may choose to proceed with criminal charges against a defendant despite the wishes of a complaining witness that they drop the case, other than merely the history of this particular party or this person's criminal history. If your case includes facts that suggest to the prosecutor that it would be dangerous to dismiss the charges, or that the facts are particularly heinous, if they're particularly severe, they have a high cringe factor, as it were, then the prosecutor might be very hesitant to dismiss the charges. The prosecutor has an ongoing duty to do justice. That's part of their ethical duty, not just to prosecute, not just to seek a conviction, but to actually do justice. And sometimes dismissal is the right thing. A good, qualified, experienced criminal defense attorney can make a big difference here. And the reason is that a criminal defense attorney with experience handling domestic battery, domestic violence, harassment claims, violations of order of protection, a good criminal defense attorney with experience might know how to address some of these concerns that a prosecutor might have where you have a complaining witness who really doesn't want to proceed. Thanks for joining me. My name is Steve Fagan from the law firm of Fagan, Fagan & Davis. We defend clients just like you facing domestic violence charges throughout Cook, Lake, and DuPage County, Illinois. If you're facing domestic violence charges and you need help, pick up the phone and call us at the number below, and we'll be happy to discuss how we might be of assistance in your case.